Let's settle down. Today we have a great morning. Good morning, everybody. I'm Tejasvi, and I'll be your host today for this event. So I'm sure that most of you have an iota of idea as to what a moot court is, because I've given an idea to D2 and D3, I believe. And the rest of the classes, I'm sure Satya sir has given you an idea. But to those who might not have heard it, moot court is a hypothetical scenario that considers a hypothetical case. Now, moot courts are usually conducted so that they can check students' possibility as to whether they can speak well in public, how well they can articulate, how deep do they consider legal arguments, and so on and so forth. So it is essentially an evaluation thing. Usually this is conducted in legal universities, law-related universities, and legal-related courses. But for us, we are conducting it with a few looser rules so that our political science students will be able to articulate themselves better and understand what legal drafting is and completely take a look into how the legal side of the whole process as to how judiciary works and all that. So today we are gathered here to have a moot court competition. We have in total 6 teams and 12 participants who are taking part in moot court. And in total, we'll be having 3 cases. Now, in order to judge these cases, we have our faculty members, Amir sir and Raviteja sir. Please stand up so that we can introduce them to the court. Please. So this is how the event is going to work. I'll first give you all a rough idea as to what the problem is. So usually a moot has a problem, and a problem is released on one day, and after a few days, the participants, they'll read their assigned problem and they'll submit a memorial, which is a legal draft. And based on the memorial, they'll give their oral submissions 2 days later or whatever time period is fixed. And today we have gathered to see the participants' oral submissions. So this event, I'll first give you an idea as to what the problem is, and then the participants will be asked to get onto the stage, and then the session will proceed. Okay? Yes? Good. All right. So first we have problem number 1. Now, to put it very simply, the problem number 1 is between a tribe named Kveleai. Now, before everything, I'll have to remind you all, this is a hypothetical case. So it is set in a hypothetical country with hypothetical characters. So this is essentially a disclaimer that we are not, none of the proceedings here are intended towards anybody in particular. Okay? So there's this tribe named Kveleai in this country named Tanvey. So the Kveleai tribe, they in their area, the government has decided to put an MPP, multi-purpose project. Now, I'm sure you all know what are the advantages of MPPs and what are the disadvantages of MPPs. One of the main disadvantages is that it displaces many lives and destroys the ecosystem of that area. Now, the Kveleai tribe, they were not given any proper notice. They did not get any proper notices. They weren't intimated of the information. So, in the end, by the time MPP project starts, they were completely unaware of it. And even during the public hearing, they were not properly called for. And when the public hearing happened, the language used was not something that they understood. Now, the court is having a case in front of it, put forward the appellant side, which is the Kveleai Tribal Council, and the respondent side, which will be the Democratic Republic of Tanvey, to say that the MPP was not properly, procedurally put in place, and we want justice. All right, do you understand what the case is? Do you understand what the case is? If I were to ask a question, will anybody be able to answer? Surely from the participants, yeah, I know. Anyways, so participants, the appellants and respondents of problem number 1, please come and take your seats. Now that the participants have taken their seat, the court will begin. All the best, participants.
Good morning, all. In the matters of the Kveleai Council versus the Democratic Republic of Tanvey, the Supreme Court of Tanvey is now in session. The court will now take appearances. Senior Counsel Appellant, introduction please. Senior Counsel Respondent, introduction.
My name is D. Sai Kiran. I appear here with my lone junior Sai Teja. We are present here to perform the Kveleai Tribal Council, represented here for the appellant of Kveleai Tribal Council.
Okay, thank you. Please introduce yourself, Senior Counsel Respondent.
May it please the court, Your Honor, Honorable Court. I am Anusha, the Senior Counsel for the respondent. My co-counsel, Beulah Rani, we are here today to argue against the claims made by the appellant, the Kveleai Tribal Council.
Okay, please be seated. Thank you, counsels. We will now hear from the Senior Counsel for Appellant. Please present your facts and submit.
May it please the court, the Democratic Republic of Tanvey is home to the Kveleai Tribe, an indigenous community whose land, culture and self-governance are protected by the Kveleai Tribal Act 2010. This act mandates free, fair and informed consent from the Gram Sabhas for any government project affecting the tribal land. In 2024, the government announced Project Jal Dhara, a major dam initiative located within Kveleai Tribal community. This project is projected to displace over 5,000 tribal members, submerge 3 tribal villages, and scathed forest and burial grounds. A public hearing was conducted 100 kilometers away from the tribal community. Subsequent to this, the Ministry of Energy claimed that Gram Sabha has consented.
A public hearing was conducted 100 kilometers away from the tribal community, and the language which is used for the communication is not in the official language of tribal people. It is in the language of the Tanvey. Subsequent to this, the Ministry of Energy claimed that Gram Sabhas had consented. However, its report confirmed that the signatures obtained from the ministry was not from the resident people of the tribal. They are outsiders of the tribal people. And there is no written notice or proper communication was ever sent to the Gram Sabhas, violating the Kveleai Tribal Act 2010. Despite this significant procedural lapse and the absence of genuine consent and a comprehensive rehabilitation plan, the government decided to proceed with the Project Jal Dhara mission. The Kveleai Tribal Council, representing the affected tribe, challenged the government actions via petition in the High Court, which dismissed the petition, asserting public interest and proper procedural adherence. The Kveleai Tribal Council has now appeared to the Supreme Court, seeking to uphold the rights and protect guaranteed to the Kveleai tribe. The appellant now appears before the Honorable Court. There are 2 issues presented before the Honorable Court, Your Honor. Whether the government failure to obtain free, prior and informed consent from the Gram Sabhas and its conduct of a public hearing without proper notice, violating the principles of natural justice and provision of Kveleai Tribal Act 2010. Second issue, whether the government's decision to proceed with Project Jal Dhara without any adequate rehabilitation and resettlement plan constitutes an arbitrary excess of power, infringing upon the fundamental rights of the Kveleai tribe. I will be dealing with the former and my learner junior deals with the later. In regards to the first issue, our submission is that there is no proper consent and wrong hearing. The government did not take real consent of the Gram Sabhas as required by the Kveleai tribal group. The public hearing was held 100 kilometers away from the tribal community. It became difficult for the tribal people to go that far place. And this is the violation of rights where the ministry have to conduct the meeting in the tribal community itself. This clearly violates the law and the principles of natural justice. right to life and equality has been violated. By initiating the project without proper rehabilitation and resettlement, the government is violating the Articles 14 and 21 of the Constitution. Tribals will lose their homes, livelihood, and dignity. The rights of life means living with dignity, not just surviving. There is loss of tribal culture and identity. The project will destroy scarce forest and burial grounds of Kveleai Tribe. This is not just a loss of land. This is the loss of culture and identity. Protecting tribal culture is part of right to life and constitutional values. Gram Sabha consent is mandatory under law. According to Section 4 of Kveleai Tribe Act 2010, requires free and informed Gram Sabha consent. Here the consent was fabricated, which is invalid according to the law. In Samatha was a state of Andhra Pradesh case which was held in 1997, the Honorable Supreme Court directed that tribal land cannot be transferred for mining without Gram Sabha consent. Article 243 and PESA Act states that Gram Sabha consent is mandatory in scheduled areas like Kveleai Tribe. No proper public hearing and violated natural justice. As the meeting is conducted 100 kilometers away from the tribal area, here we can clearly see that the law is violated. In EP Royappa and state of Tamil Nadu, the court has opined the arbitrariness is antithesis of equality, which means opposite to the equality. Article 14 prohibits arbitrariness. False signature of non-residents do not amount to valid Gram Sabha consent as they are non-residents of the tribal community. But undermining democratic representation, by considering the above arguments, the council has provided that the government failed to obtain free, prior and informed consent and conducted an unfair public hearing. Further issue will be advocated by junior lawyer.
Respected senior counsel, could you briefly explain what is meant by PESA Act?
PESA Act, which means Panchayat Extensions to Scheduled Areas.
Okay.
This act helps to protect the basic laws of the tribal people. If the laws are violated, they can consent with the PESA Act directly.
Then what is meant by principles of natural justice? You have mentioned the violation of principles of natural justice.
Here, the fairness, impartiality and giving both sides of equal is not done. The natural justice says that everyone must get a fair chance to be heard. But here, the tribal people has not got the fair chance to be here, as the meeting is conducted in the official language of Tanvey.
Then what is Project Jal Dhara?
Project Jal Dhara is a massive dam project which is helpful for the irrigation and hydroelectricity. This project is appointed by the central ministry and which was taken up by the Ministry of Energy.
So this is very good for the benefit of the society and welfare of the people. Why you are opposing this dam?
Yes, Your Honor. It is benefited for most of the people. But in a democracy, majority is respected and minorities are protected. In majority rule, if majority rule crushes the minority, they fell and they become depressed and oppressed. And leading to the conflict which was seen by the Sri Lanka 24-year crisis.
What protections under Samatha versus Andhra Pradesh apply here? And what are the articles quoted in this case?
Article 14, 21. What are the rights which were included in fundamental rights? All the rights are included in this case,
Okay.
Your Honor.
Okay.
Thank you, counsel. We will now hear from the junior counsel for appellant.
May it please the court, Your Honor. In regards to the second issue, our submission is that state acted in arbitrary and unfair manner. This violates the rule of the state. State actions must be fair, justice and reasonable. Development cannot be one-sided. Principles like sustainable development and the public trust doctrine requires the people and environment to be protected. and not sacrificed. Right to life also includes the livelihood, shelter, and dignity. Displacement without the rehabilitation destroys the livelihood and dignity. In the case of Olga Tellis and the BMC, which means the Bharat Municipal Corporation of 1985 case, the court has recognized that the right to livelihood is a part of Article 21. In the Chamli Singh case, Chamli Singh versus the state of UP, in 1996 case, that the Honorable Court recognized the right to shelter is fundamental. According to the Article 46, directs the state must protect the weaker sections. The tribal culture and the identity are constitutionally protected. The project of the Jal Dhara destroys the scared forest and burial grounds and cultural identity. The Samta versus State of Andhra Pradesh 1997 case, the court recognized the protection of tribal and land and cultural identity. According to the Article 29(1), also includes the right to conserve the forest, distinct culture. As sustainable development is constitutional duty, the development cannot ignore the rights of people. In MC Mehta versus the Kamalnath case, the court has propounded the public trust doctrine, where it identifies the shelter, where it identifies the state as the trustee of natural resource. Article 48A, which is directive principle, mandated the state to protect the environment. The government approved the Project Jal Dhara Fundamental Rights Article 14, 19, 21, 29. Special protections as Article 244, PESA Act, directive principles and duties such as Article 46, 48A, 51A, G. Thus, the protection is unconstitutional, arbitrary, and injustice. The Honorable Court shall strike it down and protect the rights, dignity, and culture of the Kveleai Tribe. In light of the facts and arguments placed before the Honorable Court, the petitioner most respectively pray the court may please to declare the unlawful approvals and taken by the government which violates the rights of the people as unconstitutional and irrational. The people direct the government to take free and fair consistent from the affected community before proceeding further. Order proper rehabilitation and resettlement of all the displaced families and justice and human manner. Protect the fundamental rights of the petitioner granted under Article 14, 19, 21, 29 of the Constitution. Pass the any order of this Honorable Court and find fit in the interest of the justice. The petitioner seeks not to wealth and power, but only on the dignity, livelihood, and rightful protection under the Constitution. It is prayed that this court may act this guardian of the justice, give the voice those who are unheard.
Respected Junior Counsel, could you clarify what is the case Olga Tellis versus BMC in the year 1985? Page number 7 you quoted.
Sir.
Olga Tellis versus BMC.
The Olga Tellis versus BMC is the case that the foundation of the argument, the dam will destroy your community of the dwellers and livelihood which was protected under the president.
What is your request?
Just guardian of the justice of voice who those who are unheard.
Dear Senior Counsel, prepare them properly, not responding properly. Just respected judge. Okay. Thank you, Counsel. We will now hear from the respondent side. Please come on.
May it please the court, Your Honor, the respondent rejects the fact scenario presented by the appellant as incomplete. May it please the court? The appellant have tried to show that the government acted against the interest of tribe. It is not true. The state adopted its duties in the constitution to promote social, economic justice, especially to the weaker section. The land was acquired legally under Land Acquisition Act 2013. The state government issued formal notifications, conducted surveys, and held several rounds of public consultations with stakeholders, including the representatives of petitioner councils. The appellant alleges that principle of free, peer, informed consent was not a duty followed and that the right to livelihood under Article 21 has been infringed. However, the respondent submits the multiple opportunities for the consultations where provide information is dismantled in local languages and platforms for objects were established as per statutory procedures. In addition, the statutory compensation respondent framed a rehabilitation resettlement package which includes monetary compensation, provision for alternative housing, employment and training scheme, and priority in procurement project-related jobs. Special attention was given to vulnerable groups, including women-headed householders and landless laborers. The project, while affecting certain families, it aims to benefit 1,000 more, improving connectivity, creating sustainable employment, and ensuring long-term social economic advancement. The respondent emphasized that the action is taken not arbitrary, but is a measured step towards the achieving equitable growth in a line with constitutional vision for social economic justice. The project is not meant to harm tribe, but it helps the entire region, which will benefit thousands of people, both tribal and non-tribal, in a long run. Finally, from our respondent side, we respect the culture and identity of Kveleai Tribe, but the development and tribal welfare can go together. This project is designed to balance the both. Your Honor, the two issues presented before the court, I am dealing with my first issue here. May it please the court? I am dealing with the first issue. My submissions are in four-folded. First, the constitutional legal validity of the project. Your Honor, the project is well within the legislative competence, consistent with Article 14, 19, 21, and further the DPSPs. Legally, it is fortified by the purpose of statutory authority and strict adherence due process. And the main sub-issue, I am dealing with the clause, the first sub-issue, whether the project violates the fundamental rights of tribal community under Article 14, 19, 21, 29, and 300A of the Constitution. Here are my submissions. The project is undertaken in the public interest for development of infrastructure, welfare, which are valid grounds for reasonable restrictions of Article 19, Clause 5. Article 21 guarantees right to life, but it has been judicially interrupted to include balance between development and livelihood. For instance, for example, Narmada Bachao Andolan vs. Union of India. The development projects are not per se violence of Article 21. And the Article 300A, right to property, allows deprivation by authority since acquisition was done under the valid of Land Acquisition, Rehabilitation, Resettlement Act 2013. With compensation, there is no illegality. And Article 14, equality, is not violated as the acquisition process appeals uniformly and is based on rational classification. Tribal community was not signed out of arbitrarily. And I am dealing with the second sub-issue, whether the state has complied with the due process, rehabilitation, resettlement, obligation under the Land Acquisition, Rehabilitation, and Resettlement Act of 2013. Here are my submission. Land Acquisition, Rehabilitation, Resettlement Act 2013, the provision of rehabilitation, resettlement, compensation, and alternative livelihood opportunities have been offered. Social impact assessment was conducted, public hearings were held, statutory safeguards were followed. And my third sub-issue, whether the right to livelihood, culture, identity of tribal population has been infringed. Here is my submission. Right to livelihood and cultural integrity. Right to livelihood does not mean right to retain land perpetually. It can be regulated for large public interest, will be adequate safeguards. Alternative livelihood, housing facilities are being provided as part of rehabilitation. Culture identity is respected through special schemes, preservation of community land, and consultation with our local leaders. And my fourth sub-issue, whether the acquisition process is arbitrary or discriminatory or disproportionately burdening tribal communities. The acquisition process does not target or discriminate against tribals. Any perceived impact is an incidental consequence of geography, not deliberately targeting. Special care has been taken under the 5th Schedule, Protection and PESA Act provisions to safeguard tribal rights. The rest of my case, my learned junior shall now expand upon the second issue. May it please the court?
Respected senior counsel, you have mentioned the public trust doctrine. What it means? Could you briefly explain?
That, Your Honor, may I please that court? The public trust doctrine. The state is a trustee of natural resources for the people. It prevents over exploitation but allows responsible use for public goods.
Okay, you have quoted the case Narmada Bachao Andolan versus Union of India. So, could you submit some facts relating to this case?
May it please the court? The yes. Narmada Bachao Andolan vs Union of India 2000. It is the development project, like dams upheld with adequate rehabilitation is ensured. It's emphasizing balance between development and environmental rehabilitation. Sir.
Thank you, senior counsel.
Yeah. Respected senior counsel, how does the state balance development and tribal rights at a time?
It can balance while as for Land Acquisition and Rehabilitation Resettlement Act 2013, the provisions are land acquisition for public purpose. First point. Second, fair competition, consultation, rehabilitation, and resettlement of affected families. From the land acquisition provision, it can be balanced because it is the project was aimed for more than public interest. It's a democratic where we focus on majorities there, but we should protect the minority rights. For that instance, we are from that act we are giving compensations for affected families. We are replacement from there. The tribes which are habitated to live in that concise place were not far to development. Through these schemes, through these projects, we can development there, and both will be happen simultaneously.
Everything is good, but any mechanism you have opted for this? Any mechanism?
Counsel, we will now hear from the junior.
May it please the court? Your Honor, I, appearing as junior counsel on the behalf of the respondents, with the court's permission, I shall address the issues specifically concerning compliance with the constitutional guarantees, international obligations, and environmental principles. With utmost respect, I submit that these allegations are unfounded and that the respondent state has acted within the four corners of the law and incomplete to both domestic and international obligations. Your Honor, the first issue concerns the question of whether the project violates the rights of the petitioners, tribal community under constitutional and international law. At the outset, it is submitted that the Constitution itself envisions a careful balance between fundamental rights and the directive principles of state policy. While the right to life under Article 21 has been judicially expanded to include a right to wholesome environment. Article 38 and 39 place a positive obligation upon the state to secure the welfare of the people and ensure equitable distribution of resources. The project in question is not an arbitrary enroachment upon rights, but it is planned development initiative that seeks to advance social and economic welfare, while simultaneously providing rehabilitation and resettlement for the affected community. In relation to the international law, it is submitted that instruments such as the UN Declaration on Rights of Indigenous People and the ILO Convention 169 through perversely are not binding unless incorporated into domestic law. In the present case, India Tanvey has enacted robust domestic frameworks such as the Forest Rights Act of 2006 and the Panchayat's extension to the scheduled areas of 1996, which expressively safeguard the participation and protection of tribal arguments. Thus, there is no violation of their constitutional or international arguments. Coming to the second issue, the petitioners have argued that the principle of free, fairer, and informed consent, as recognized in UNDRIP and ILO 169, has been disregarded. With the court's leave, I submit that this is mischaracterization. The principle of FPIC, through pervasive, does not grant an absolute veto to the community to shall any development project. Rather, it requires meaningful consultation, emphasized the importance of consultation with tribal communities, but it has never equated consultation with absolute consent. The respondents state as in fact undertaken extensive consultations through Gram Sabha meetings and public hearings, the records of which are on the record before this Honorable Court. Rehabilitation and practices and livelihood opportunities have also been integrated into the project plan, demonstrating the state's bona fide intent to protect the interest of the community. Hence, it cannot be contended that the principle of FPIC is violated. The third issue pertains to whether the environmental impact of the project was adequately assessed in the light of the precautionary people, sustainable development, and Tanvey's commitment under the Rio Declaration. My honor, it is respectfully submitted that the project has undergone a comprehensive environmental impact assessment in street with the EIA notification 2006. Mitigation measures such as afforestation drives, biodiversity offsets, and pollution control mechanisms have been incorporated. This Honorable Court has upheld that developmental projects can proceed as long as safeguards are respected. Furthermore, the doctrines of precautionary principle and sustainable developments are fully satisfied. In Value Citizens Welfare Forum versus Union of India, this court held that precautionary principles requires the state to anticipate and mitigate potential harm. In the present case, multiple preventive safeguards have been embedded into project design. Similarly, in Narmada Bachao Andolan versus Union of India, this court clarified that sustainable development does not mean development at the cost of the environment, nor it means environment protection at the cost of development. It is balanced, and that balance has been carefully achieved here. With respect to Rio Declaration, it is humbly submitted that India's commitments thereunder are not violated. Principle 2 and 4 of the Rio Declaration clearly acknowledge the sovereign right of the states to exploit their own environment and developmental policies. What is required is adherence.
Please.
Therefore, in the light of the facts and submission, here in the above, the respondent most respectfully pray before this Honorable Court that it may please to dismiss the claims made by the petitioner, uphold the validity of the acquisition, the project undertaken by the state, recognize the compliance of the respondent with the constitutional and statutory obligation, pass any order as this honorable court may deem fit in the interest of justice and equality.
Okay, just a minute. Without providing any alternative measures to the tribal community, how can we dismiss the petition? It is a mandatory duty of the government to provide alternative measures like provide the shelter. Okay, provide the shelter, and government has the duty to respect their culture, language, livelihood, but you are seeking the government to dismiss the petition. So what steps you will going to take?
May it please the court, Your Honor, respectfully, information does not require perfection in procedure, but reasonable opportunity to participate. The Ministry of Energy provided public notice, organized a public hearing, and tribal representatives attended. While logistical challenges existed, the principle of doctrine of proportionality applies. Minor procedure shortcomings cannot nullify a project of immense public benefit such as irrigation and hydroelectricity, which serves beyond the impaired locality. And coming to the rehabilitation, Your Honors, the state has already committed to rehabilitation under the Land Acquisition, Rehabilitation and Resettlement Act. Article 21 is not violated where the state ensures livelihood through structure compensation and resettlement schemes. Article 300A only requires a deprivation of property by authority of law.
Thank you, counsel. The court is now open for rebuttal. Do you have any rebuttals about their arguments?
Yes, Your Honor.
Yes.
As my respondent said that facts are incomplete. Your Honor, facts means it should be not biased. It should be like facts only. And next thing, our respondent said that affecting few families but benefiting more people. Your Honor, displacing even one family without justice is unconstitutional. Here, more than 5,000 people are being displaced from Kveleai Tribal to faraway places. And she also mentioned that development can be balanced. Development cannot be built on the graves of marginalized people. Here, the marginal people refers to Kveleai Tribal Group. Development only valid if it respects the constitution. Here, the government has done so many illegal, means unconstitutional things which were amended on the Kveleai Tribal Group. And my respondent said that rehabilitation can be done later and compensation can be given. Okay, my lord. Rehabilitation after displacement is like medicine after the death. Article 21, rights to live with dignity, states any action affecting shelter, individual dignity must be invalid. The court in Chimili Singh was a state of union. It held that right to shelter is the part of right to life. It cannot be taken away first and restored later. And my respondent mentioned that compensation is paid. Your Honor, compensation paid cannot restore the land. This is not just a land. It is the land of values, culture, and the dignity of the tribal people. As the tribal people are indigenous people, it must be conserved and protected for the Kveleai Tribal Group. Thank you, Your Honor.
Okay, you can proceed now.
May I please the court, Honorable Your Honor, Honorable the Court. The respondent rejected fact scenarios presented on appellant is incomplete. Facts are incomplete because the appellant tried to show that government acted against the interest of the tribe. This is not true. And second point, the Land Acquisition Rehabilitation Resettlement Act 2013, the government is following and doing through constitutionally Article 21, right to life, right to dignity of life. Here subclause we can add right to development will come to the Article 21. My appellant phrases that we can't develop minorities. Our government is focusing on, in 2024, the government of Tanvey announced Project Jal Dhara. Here is discussion about a massive dam, which is about 5,000 people who are employing, who are getting jobs, who are getting beneficiaries from this. This project is hydroelectricity power and it is a eastern region. I think from this project, it will be help and it will overcome the minorities or indigenous groups. And our government did not affected any culture and religious of the Kveleai tribe. We respect the Kveleai tribe culture and religious. But as a fact that the Kveleai tribe they were isolated in a forest. The forest is a way of living for them. But the Kveleai people of the Kveleai tribal, they are the many people we can educate, we can give houses, we can give employment, and we can isolate. They were isolated, so we need to integrate we need to interconnect with our society. And this project is for public interest. We will accept the indigenous tribal Kveleai. And again, the petitioner mentioned Article 21, but the government was followed the rules of constitution, and we are adopted statutory laws also. That's it.
Okay, thank you, counsels. Okay, so arguments are over on this case. So the judgment is reserved for on Monday. Okay, you can leave.